So we have some major developments right now that cannot be ignored when it comes to suppressors and short-barreled rifles and how they are treated under federal law. Across the country, the conversation has shifted in a way that would have been unimaginable just a few years ago. And now we are staring at a moment where decades of restrictions are being directly challenged not just in court, but also in Congress. 15 states have stepped forward in direct support of ending the remaining National Firearms Act restrictions. And at the same time, the Supreme Court has shown interest in reviewing the questions surrounding SBR regulations. These are not minor moves. These are major shifts in the way our laws are going to be tested and potentially rewritten. Before diving deep into the lawsuits and the political battles of today, it's worth stepping back to remember where this all started. The National Firearms Act was passed in 1934, and at that time it imposed a $200 tax on certain classes of firearms, including suppressors and short-barreled rifles. Today, $200 doesn't sound overwhelming, but in the Depression era it was equivalent to several $1,000s. That price tag was chosen specifically to deter ordinary ownership. It wasn't designed as a routine fee. It was meant as a barrier that would keep these items out of civilian hands. For decades, courts accepted the NFA as a valid exercise of Congress's taxing power under Article 1 of the Constitution. That was the legal foundation, not that Congress could outright ban these items, but that it could tax them so heavily they would be inaccessible. That logic carried on for almost a century without much challenge, even as firearms technology changed and political debates about the Second Amendment intensified. In recent years, gun rights advocates pushed hard for the Hearing Protection Act and the SHORT Act, both aimed at removing suppressors and SBRs from the NFA framework entirely. The goal was simple: treat them like ordinary firearms and end the complex paperwork and delays that make their purchase a headache. Supporters thought they might succeed by attaching these reforms to a broader legislative package. That chance came with H.R. 1, known as the One Big Beautiful Bill. The bill passed and the president signed it into law, but the outcome was mixed. Here's why the Senate parliamentarian ruled that the provisions eliminating suppressors and SBRs from the NFA violated the Byrd Rule. Under that rule, items in a reconciliation bill must directly affect spending or revenue. Because the outright repeal didn't qualify, the language was stripped out. What remained was a partial but important win. The NFA tax was reduced from $200 to $0. That change is more than symbolic. The constitutional foundation of the NFA has always rested on it being a tax measure. When the tax vanishes, so does the justification. What's left is a regulatory scheme without the legal footing that once made it valid. That's why this adjustment has become the centerpiece of a wave of lawsuits now moving through the courts. Not surprisingly, Democrats quickly tried to push back. Senator Chris Murphy introduced an amendment to a defense spending bill that would have raised the tax not just back to $200, but to $4.709 per stamp. That figure wasn't random. It reflected the inflation-adjusted value of the original 1934 tax. The intention was clear: restore the deterrent effect by bringing the cost back in line with its historical weight. Whether such an amendment has political legs is another question, but it demonstrates how determined opponents are to undo the zero tax provision. On the other side, gun rights groups launched an aggressive legal strategy. Organizations like Gun Owners of America, the Firearms Regulatory Accountability Coalition, Silencer Shop Palmetto State Armory, and Silencer Co. filed suit. Their argument is straightforward. The NFA was upheld as a tax law, but now that the tax has been set to zero, Congress has lost its constitutional basis to enforce the registration and transfer requirements. Without that foundation, the law overreaches. Entire states have joined in as well: Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming, 15 in all, have signed on to the challenge. That kind of state-level coalition directly confronting a federal firearms law is unprecedented. They aren't simply voicing support, they are formally backing the legal fight to dismantle the restrictions. The choice of forum matters too. The suits were filed in the Northern District of Texas, a jurisdiction that has built a track record of rulings sympathetic to Second Amendment claims. Judges like Reed O'Connor and Matthew Kaczmarek have handed down decisions favorable to gun rights in cases involving so-called 80% receivers pistol braces and forced reset triggers. Filing in that district was a calculated decision intended to set strong precedents before appeals move upward. While these district court battles unfold, the Supreme Court looms large in the background. Two petitions, Rush and Robinson, directly challenge the NFA's treatment of short-barreled rifles. Both argue that the restrictions violate the Second Amendment. Initially, the Trump DOJ waived its right to respond, But the court recently ordered the department to file briefs anyway. That small procedural step is meaningful. It shows the justices are paying attention and signals that the issue is very much on their radar. If they choose to grant review, the consequences will extend far beyond the pending district cases. A Supreme Court ruling could reshape the entire legal landscape for suppressors and SBRs. Now the lawsuits raise arguments that cut directly to the core of the NFA. The plaintiffs insist that Congress justified the law only as a tax measure. For 90 years, the $200 requirement was the hook. Once the One Big Beautiful Bill reduced that tax to zero, the legal foundation collapsed. What remains is a regulatory framework with no constitutional footing. Congress does not have unlimited power, and when the taxing authority disappears, so does the justification. The plaintiffs want courts to recognize that reality and declare that the act can no longer be upheld. Their complaints point out that registration and transfer rules still exist, but they are now divorced from any taxing purpose. Fingerprints, paperwork, and waiting periods are still demanded, yet the tax that once supported those demands is gone. The plaintiffs ask the courts to strike down these requirements and to block the ATF from enforcing them. If granted, suppressors and SBRs would no longer fall under the NFA's heavy hand. The lawsuits were filed in the Northern District of Texas, a venue chosen for its track record. Judges there have consistently scrutinized expansive federal rules. Decisions striking down restrictions on pistol braces, forced reset triggers, and 80% receivers have come from this district. Filing there was no accident. Advocates know it is fertile ground for strong precedents that can set the stage for higher courts. At the same time, the Supreme Court is watching. Two petitions Rush and Robinson directly challenge the NFA's treatment of short-barreled rifles. Both claim the restrictions violate the Second Amendment. The court recently ordered the Department of Justice to respond even after the Trump DOJ initially waived that opportunity. That is not a routine move. It signals that the justices are paying attention. If review is granted, the decision will carry national consequences. A ruling against the NFA would make many of the district-level fights unnecessary and reset firearms law across the country. The Department of Justice and the ATF remain central players. On certain points, they have acknowledged that items like suppressors qualify as arms protected by the Constitution. But they also defend the NFA by casting it as a shall-issue permitting system. Their argument is that because most applications are eventually approved, the law functions like the licensing structures the court said were permissible in the Bruin case. In their telling, the NFA is not a ban, but a regulated process. Critics respond that the comparison is flawed. The NFA process is not a simple licensing system. It is slow, invasive, and deliberately discouraging. For decades, the original $200 tax reinforced that burden by making ownership financially impossible for ordinary citizens. Even now, with the tax cut to zero, the paperwork and registration remain, and they exist without the legal foundation that once justified them. The plaintiffs argue that this exposes the law for what it is: regulation without constitutional authority. Opponents of deregulation continue to press their own arguments. Gun control advocates claim that making suppressors and SBRs easier to obtain threatens public safety. They warn that suppressors could conceal gunfire and that short rifles are more concealable for criminals. These talking points are not new, but they are being used to rally support for keeping the NFA intact. The fight is not only legal, it is also political, and both sides understand the stakes. As the litigation unfolds, timing is uncertain. If the Supreme Court takes the Rush or Robinson cases, lower courts may pause their proceedings and wait for guidance. That would not be a setback. It would be a chance for a sweeping ruling that clarifies the issue nationwide. If the court declines the cases in Texas, and the Fifth Circuit will continue, and strong victories there could still drive the matter back to the justices later. Either way, momentum is building, and the conflict is moving toward a decisive outcome. The government's approach so far has been inconsistent. In some situations, the DOJ has taken positions that sound open to Second Amendment arguments. In others, especially in challenges to machine gun restrictions, it has doubled down on defending the NFA as constitutional. That back and forth makes the future hard to predict. Depending on how aggressively the DOJ decides to fight, cases could move faster than expected or stall in lengthy appeals. Still, the fact that the tax has been zeroed out means the core argument will continue pressing upward through the courts. What is undeniable is that the NFA is under pressure like never before. Lawsuits are active in federal court, petitions are pending at the Supreme Court, and states have taken sides. 15 states are formally backing the challenges, while others quietly side with the federal government. For almost a century, the NFA stood untouched. That era is over. The assumptions that kept it safe are gone, and the courts are being asked to decide whether the government can continue enforcing a law built on a foundation that no longer exists. For Second Amendment supporters, this is a rare opportunity. The opposition is mobilized, but the conditions have never been better to challenge a law that was crafted in the 1930s to suppress ownership through financial barriers. Whether the breakthrough comes from Texas, the Fifth Circuit, or the Supreme Court, the trajectory is clear. The fight is alive. It is moving quickly, and it carries the potential to redefine how Americans exercise their rights. And that is why staying engaged matters. The conflict unfolding right now is not a minor debate. It is a fundamental question of what powers Congress holds, what limits the Constitution imposes, and how far the government can intrude on the right to keep and bear arms. The future of suppressors and short-barreled rifles will be shaped in courtrooms and in Congress over the months ahead. This nation was built by people who insisted on their rights, and it will be preserved only if that insistence continues.